Court is now in session. Please be seated.
Just a second, I gotta reorganize here. All right, well, I am Justice Joseph Ditkoff, and will be the panel for the rest of the morning. I'll call the second case, Commonwealth, number 24P110, Commonwealth versus Calhoun. Counselor, whenever you're ready.
May it please the court. This is an appeal of a probation revocation hearing. The standard is essentially abuse of discretion, and I'm going to focus just on two issues and ask if there are any other questions I can answer. But the first issue is with respect to the probation officer not being able to find, or the fact that it was found that the probationer was not in contact with his PO. So if you recall, at the very beginning of the hearing, and I also mentioned that the probationer defendant has type 1 diabetes. This does not seem to be a fact that is contested at all in the record, and he actually does have type 1 diabetes, which does require a great deal of medical attention. For example, when your blood sugar is high or when it's low, it requires a lot of medical appointments, not only meeting with your doctor, but also nutritionists. In this case, there were two. The defendant said that he had been hospitalized in two portions. At the very end of the hearing, certain portions of those medical records came in, and the judge didn't look at that. The second issue was that the defendant had said that he was at Mass General for a second portion at the end of, I think it was September or August. And there was discussion on the record about trial counsel not getting that material. So I have that material. It's in the appellate addendum. Are there any questions as to why that came in? It didn't come in. The defendant is upset with trial counsel and wants you to look at a motion for ineffective assistance of counsel based on that. I discussed with my client the usual routes by which that is brought up. He felt that if you could see the Mass General record, that would add credence to his claim that he had told trial counsel about it and they didn't get it. I think he's hoping that this court could at least put in something in the opinion that the trial court should look at maybe reopening this material so that that can be submitted.
The medical records don't cover August 12th to the 21st and September 1st to the 9th, is that right?
That's right.
Because that's a pretty big chunk of time. That's not actually, even if we were to consider the records, that's not actually covered and doesn't justify.
That's true. So what we're talking about is, there's not like a set time where you check in, at least under this record. The court talks about how if you're not in contact with your probation officer for days.
Every 2 weeks, right? Isn't that the requirement?
Yes. And in this case, the defendant, my client, would like you to know that he always did stay in contact with his probation officer. In fact, the police knew where to arrest him because he had told his probation officer exactly where he was staying. In a footnote, I discussed that it seems like the PO acknowledged that, but he said that seemed to be a change of address. That seems a point of contention between my client and his probation officer. He didn't view it as a change of address. He didn't want to go stay in a halfway house. I think he felt comfortable staying with, I believe it was his cousin. But again, he gave that information to the probation officer. Police knew exactly where to find him. So he does not feel that he was ever out of compliance with his
conditions.
His probation record.
But didn't the condition require him to report in person every 2 weeks?
So this often takes it's subjective with respect to the probation officer. Every probation officer seems to be different, and sometimes when you start out that way, a probation officer might just say, go ahead, just call me, let me know. That doesn't seem to be fleshed out in this record.
It might be a de minimis violation if it was a call instead of a report in person. It wouldn't ever be
Yeah, and in fact, I think there was a portion where they were explicitly talking about the first group of medical records that came in, where the probation officer was saying, you know, just call me, let me know where these, or that you're going to get me those records. So it seems to be calling seems to have been the main way that they were in contact with each other.
So, Counselor, I understand and appreciate why the brief is written the way it is, but I have a little difficulty in making sure I understand the issues being raised. So we've just talked about whether there was a preponderance of evidence that his whereabouts were unknown. So I got that. And there's the ineffective assistance.
Yeah.
What else am I adjudicating?
The new charge. As you might imagine, my client is extremely upset that this was used. Later, the material was dismissed. My sister brought the video so you can kind of see the video that was entered as an exhibit. I don't think it's helpful. Actually, I found the description in the record quite a bit more helpful. But he did not commit a new, well, he claims that he did not commit a new charge. Even though he was charged, those were later dismissed.
But the argument as to the new charge, is it that there wasn't enough evidence to find that he committed the new crime, or is there something else?
No, there was not enough evidence to find that he committed a new crime, absolutely.
Okay.
And when looked at as a whole, this is a probationer who was doing his best to stay in compliance. Even though he had diabetes, he made sure that he submitted medical records. It would have been much more helpful if trial counsel would have obtained that second group from Mass General. I understand the standards are difficult in these cases, but nonetheless, I'm sure that you understand that what we're talking about is, even though it's a conditional liberty interest, it's still a liberty interest of my client. And looked at as a whole,
But there was surveillance footage from the T station and showing that
feel free to look at it. It won't help you a bit. It doesn't show a thing.
doesn't show they grabbed the victim's neck.
There's a reason why these charges were dismissed, and you'll see. I think it's in the record. It shows pretty clearly that there's nothing that my client did that was prosecutable. Maybe not in a good situation at the T.
What's
but
the standard for a probation violation? It's not. I mean, it seems like a somewhat different standard than a criminal.
The standard, for the standard review, I cite that on page 19. You're to review the probation revocation decision to see, quote, whether the record discloses sufficient reliable evidence to warrant a finding by the judge. Essentially, the appellate court reviews that finding under an abuse of discretion standard.
So my understanding is that what the judge was considering is whether or not the video footage corroborated the alleged victim's statements to the police officer.
Yes.
And so they didn't the video footage didn't necessarily have to depict the crime.
No, but it did show that they were still chummy or together after the supposed event.
And before.
And before, and the claim of theft seems to be a little tedious in the sense that he's talking about things like high-end electronics that might have been taken. So you can do with that what you will, but it doesn't seem like there's enough evidence to show, even by a preponderance. I understand that's low, but even by a preponderance, when you weigh that against a liberty interest, even though conditional. It's important that these things are reviewed to make sure that the standards are met. If there are no other questions, I think those are the 2 points that I wanted to bring out.
Thank you.
Thank you, Counselor.
Good morning. May it please the court. Kyra Kosh, Assistant District Attorney for Middlesex on behalf of the Commonwealth. We asked this court to affirm the revocation order as the defendant's violations of probations. There were 5 that were the basis of the revocation. 3 of those are not contested and were not contested below. To start with the offenses out of BMC, this violation was well supported. The judge considered the police reports, the detective's testimony, the photographs and surveillance video showing the actual commission of the offenses. I did present the video this morning to the clerk's office, and I believe it is very helpful. You do see the parties entering the elevator, and then at one point the elevator opens and you see the defendant has his arm around the victim. Although you can't exactly see the full body of the victim, he's in the side of the elevator next to the door, and you see the female who is accompanying the defendant taking things out of the victim's pockets and throwing them on the ground. And then when the elevator opens, eventually, there's about a 2 minutes altercation in the elevator where you can only really see through the little window. But you do see the parties get out. It is not exactly as chummy as defense counsel is describing. The defendant first exits with the female who is accompanying him, and then shortly after, the victim comes out. And as the judge described, he looked like he was hiding, like he was scared. And based on all the evidence, the judge stated at transcript site volume 2, page 28, that there was sufficient proof that the defendant committed not only the charged offenses of armed robbery and strangulation and/or suffocation, but also the lesser included offense of robbery, assault and battery, as well as that the defendant's involved in prostitution or human trafficking. And so based on all that, I believe that that violation is well proven.
What's your understanding of the duty to report to probation? What exactly was it? Was it duty to report in person?
Yes, the probation officer stated at the hearing that his reporting requirements were to report in person every 2 weeks, which the defendant did not do. He stated that he did not report in person at all for the months of August and September. And so as to the defendant's claim of ineffective assistance of counsel, I believe that claim cannot properly be disposed of on this record. The medical records are not properly a part of the record under Rule 8 because they were not presented below. But again, as Justice Toone pointed out, the period for which the medical records cover, August 21st to September 1st, does not cover the whole period of whereabouts unknown. And it was
If the only evidence before Judge Wall was that the defendant had failed to report in person to his probation officer, do you think he would have been violated?
I believe so. I think that would still be sufficient if the judge credited the probation officer's statement. But in any event, even if the defendant was in the hospital during those dates, presuming that he was based on the medical records, there is no evidence that he was not able to at least call his probation officer while he was in the hospital. I understand that he did on August 10th when he was in the Leahy clinic. He did call his probation officer. Both of them had argued that. But in any event, this is not the rate.
And on the 18th, right? Probation officer testified he had telephone contact on August 18th.
So first he stated it was August 10th. I think he got the dates mixed up. August 18th was the date of the new offense. My understanding is that it was August 10th that he had contacted his probation officer, but that's outside of the period of the whereabouts unknown. That was August 12th, the date he was discharged from the Leahy clinic, to September 9th when he was picked up on the new offense. So again, the other violations, the failure to remain drug-free, noncompliance with drug testing, and failure to appear at the final surrender hearing were not contested below. So the defendant's violation of his probation and the revocation were well supported. Unless the court has any further questions, I'll rest on my brief.
All right, well, Ms. Kosh, welcome back.
Thank you.
Congratulations on your first argument. We hope to see many more. It gets a lot easier when you wrote the brief.
Yes. Thank you, Your Honors.
Thank you both. All right, I'll call the third case, number 24P113, Commonwealth versus Johnson. Whenever you're ready, Counselor.
Good morning, Your Honors. Jocelyn McGrath for the Commonwealth. So we basically have three issues. We have a search incident to arrest on an outstanding warrant, a search of the bag in custody from probable cause for drugs, and a 1311-2 issue on particularity for notice in a motion to suppress pleading. We're asking the court to reverse the allowance of the motion to suppress because our position is the judge erred by applying the wrong law to the to the first search incident to arrest, and then basically cascading into the second one not being addressed, the second search and probable cause. I think the most interesting aspect of this is really that first search incident to arrest on the outstanding warrant, because the grounds that she presented in her decision, she basically just has two statements and cites to two cases for this part of the search. She cites first Blevins, which is a 2003 key case. There's a line of cases. Some are pill container cases, some are key cases that have to do with search incident to arrest, mostly on the proposition that an officer cannot go forward on an unrelated search. I call them secondary searches in a footnote. So basically,
When you say she cites, oh, sorry, never mind. I see it. The judge cites to Blevins.
Judge cites to
Yeah.
Blevins. In a sense, we're not arguing with the defendant's trial attorney at all. We're really just going straight to the decision, the grounds for the allowance, which we think are error because the wrong law was cited. And
Well, we're not, I mean, it's not our job to edit the lower court decision. We got to decide whether the search was okay. And while I don't doubt that in a search incident arrest, an officer can go through an arrestee's pockets, if the officer decides instead to pat frisk, and in pat frisking doesn't have any indication of a weapon or evidence of the crime, why isn't that the end of it?
I guess we disagree with that proposition.
Which one?
The proposition that if an officer doesn't feel a weapon from a pat frisk, which I think it's good to get our terms clear maybe from the beginning. There is a protective pat frisk, which is part of an investigatory Terry-type stop. And then there's also a pat frisk, which is just a mechanical application of the hands to the body through clothing. So the pat frisk, the mechanical application, is used in different contexts. But this wasn't a Terry-type stop. This wasn't an investigatory stop, so it doesn't have the same privacy issues. It doesn't have the same necessity for the officer to believe there's criminal activity, believe the person was armed and dangerous, have articulable facts that the person is armed and dangerous. It's very, very stringent, high standard. This is outstanding warrant. It's already decided this person is arrestable. As soon as the officer finds out he has an outstanding warrant.
We have no idea what the warrant was for, right? And that doesn't really factor into the analysis.
It does not factor
So
in.
under Chapter 276, Section 1, it's only about, the search is only allowed to remove any weapons that the arrestee might use to resist arrest or effect his escape, right?
That is the correct language, Your Honor. And what we'd like to get.
Is there a but there?
You know, I'm laughing because we were going through this a lot. 276, Section 1 appears to be very stringent. It appears to be very exclusive, you can only do it for this purpose or that purpose. But I think courts have correctly interpreted it in the context in which that, in the legislative intent. The legislative intent was basically in response to the U.S. Supreme Court case, Robinson, where there was a secondary search. It was very alarming because it started with a car infraction. And then basically he was, the officer was rummaging around. And our legislature became very alarmed and wanted to put a stop to that and make sure that in Massachusetts, at least, you couldn't have an unrelated search if you couldn't justify it on safety, or you're actually trying to find evidence of the crime that the person was arrested on. So they use what I would say classic legal language, but the intent was to restrict this particular problem. So therefore, we have the key cases. We have the pill bottle cases. These are objects where they're very tempting for a secondary search, for an unrelated search. So in a sense, that's...
Well, they're hard objects, right? They're hard objects that may contain weapons, right? That's what happened in White, right? You feel, oh, that's a hard object. Let's find out what's inside this little, hard plastic object, right? Here, the feel was for packets of drugs and bills, right? Is there an argument that that feel gave rise to a suspicion of a weapon?
No, not at all. We don't need it in this case.
But that's what I was trying to ask. an officer could search pockets, but if the officer decides instead to frisk, and the frisk tells them there's no weapon in the pockets, why isn't that the end of the search incident to arrest?
If an officer decides to pat frisk,
Yeah.
cannot tell if there's an object that is a weapon. I'm just trying to follow this because,
An officer arresting someone decides he's going to frisk them, going to pat him down, and when he pats him down, he doesn't feel anything hard, anything that could be a weapon. Why isn't he done with his search incident to arrest?
well, 276, Chapter 1 is based on the idea of you can search for criminality, more evidence of criminality, or for protection for the officer and to prevent someone from escaping. What I think is really, you can tackle this from both ends. One is from this idea of legislative intent. Courts have correctly interpreted a limitation on secondary objects. And you can also go let the intent that the safety does changes, but does not necessarily diminish over the course of the arrest, the custody, and the intent to put someone in the back of a cruiser. I would like to actually put forward a case that Attorney Schneiderman found and put in his brief, which I thought was incredibly helpful. It's a 2020 SJC case that
Counsel,
addresses this.
I'm going to try one more time.
Okay.
Then I'm going to give up.
Oh, dear.
If the officer arresting someone frisks the person and then doesn't think that there's any weapons, anything hard in where they frisk, why do they get to keep searching incident to arrest?
It's a safety concern. If you're putting someone in a cruiser, the idea of what can be dangerous or being used for escape or resisting arrest, there's still a risk of any object being used as a weapon or as a means of escape or as a distraction.
So if the defendant had a piece of string in his pocket, a shoelace, say, that could be used as a ligature, would that be a weapon for the purposes of 276-1?
Thank you, Your Honor, yes. And
If it were, say, a razor blade flat against his body that couldn't be felt?
correct, the traditional idea of a hard object, a weapon as only being a large hard object is not realistic to
So
weapon.
does weapon mean something different in the context of a Terry stop than it means in 276-1?
Yes, it does. It does.
So you want to get away from all the case law that talks about finding hard objects, right? Because there's no argument here that the officer felt a hard
No,
object.
I think the SEC also wants to get away from the language of hard objects. The case that I was about to reference was Commonwealth v. Barillas, which is a 2020 SJC case. Basically, they take U.S. Supreme Court language that really says that unknown physical objects may always pose risks, no matter how slight, during the tense atmosphere of a custodial arrest. Notably, this isn't a search incident to arrest. It's a cell phone, which is a hard object. They justify it under the weapons prong, but then they don't cite to Clermy, they don't cite to Blevins or to White. They really, I think they do want to put sort of a top on this, saying like, there is a continuum, and I think the legislature was very concerned with this particular problem that they perceived. But there's this whole range of a continuum of an officer's continued need to keep things safe.
So if you think that's where the SJC is going, maybe you should bring that argument to the SJC. But that seems a lot for us to say, well, here's really what the SJC means, and we're going to kind of dispose of all the hard object case law and come up, and say, gosh, anything could be dangerous. So search the pockets, do what you want. There's no limitation imposed.
Your
by-
Honor, I would put that differently. I would
Okay.
put that. I would put it that this line of cases is relevant to a very particular situation. The legislative intent was very clear, which is why they put the legislative intent into these cases. The hard object language sort of got baked in, but it doesn't exclude other types of objects, the ligatures, the hypodermic needles, the razors, even the paper clips and the bobby pins, because we're talking about a whole range of objects that can cause a lot of problems when someone's in the back of a cruiser. And in the case law, also just sort of like, as a matter of fact, describes sort of first searches and then like thorough searches before a person in custody is put in the back of a cruiser. We don't want to chill officers saying, I can't actually search you because I'm about to put you back in the cruiser, but I haven't actually felt something that is, I can absolutely know as a weapon.
So is your position then, if there's initially a pat search, pat frisk, and any object is detected, then there can be a secondary search? Because, gosh, anything can be dangerous, including, you know,
I think it's more that
laces or tooth floss or whatever.
people are very creative when they're desperate, and there's a sense that it's the officer's responsibility to keep him or herself safe, the defendant safe, and the community safe, because if someone actually is causing escapes or it manages to, there's an underlying safety issue to 276 Section 1. It is not well developed, but it doesn't stand for the principle that an officer is not allowed to go into a defendant's pockets, make sure there isn't a weapon. That's not what it stands for. It stands for, if you have a solid object and it's not obviously a weapon, you can take it out and examine it, but if it's a pill container or a key, think twice before you use that power object, like the key, for a further investigation, or think twice about opening that pill container, because you may not have probable cause to open that pill container, and you can't tell if it has a weapon.
So the judge here, in your view, should have said, yes, I know that all this case law talks about hard objects, but I've got to guess where the SJC is headed, and therefore I'm going to sort of not really follow that line of cases and sort of say any secondary search is allowed because things can be dangerous even if they're soft.
Your Honor, I love the language of this SJC case because it explains something, which is any object can pose a risk. And I think we feel this, that it's not a good idea to put an arrestee in the back of a police car without thoroughly knowing what's on their body. And it's within other parameters of reasonableness. We have this very stringent language, but it's not applied correctly to not being able to search someone thoroughly before you put them into the back of a cruiser. Is that fair?
I'm not going to say it's fair, but I understand your position.
I mean, I know the SJC case, that's really on your mind.
I'm not sure what this judge was supposed to do, because she seems to pretty much follow precedent about no hard object, no secondary search, and you're saying, gosh, that's just not, that can't be the rule.
I disagree. I mean, she cites to basically...
Cites to White, right? White's.
I think tangentially for the standard, but the second time she cites for the principle that the items were not immediately recognizable as contraband by the officer, she cites to Wilson. That is the classic Plainfield case. That's the 2004 case. I think Blevins, she misunderstood it. She pulled out language that was not in context. I don't think Blevins stands for the principle that the officer did not feel any hard objects in the defendant's pockets that could be used as a weapon, therefore couldn't search any further. Because I think Blevins actually is pretty self-explanatory. Blevins says, because the seizure of the keys was justified solely as a result of a search for weapons, the troopers were entitled only to remove them from the defendant for safety purposes, not for purposes of investigation. Blevins is actually very clear that it's really trying to limit further investigations, not limit the removal of objects from a person, and that the objects can be hard, but it doesn't necessarily mean that they don't fit into that weapons prong as the courts have interpreted it.
I have one more question. Yeah, sure. Just to be clear, as to the officer's immediate search of the bag and seizure of the gun, do you have any argument as to its legality that doesn't depend on the legality of the heroin and cash being seized at the time of arrest?
The heroin is the probable cause for the search of the bag.
Okay, and there's no other argument that the bag...
No other argument.
Thank you.
You're welcome.
All right. Thank you, Counselor.
I beg Your Honor's indulgence. I fell this morning. I'm a little sluggish, so...
Do you want to sit down?
No, Your Honor. Thank you, though. I appreciate that.
All right.
If you want to sit down at any point, feel free.
Absolutely.
Thank you, Your Honors. Good morning. May it please the court. I am Joseph Schneiderman. I represent Brandon Johnson. I'd like to start by responding to some things that Justice Toone and Justice Ditkoff had asked about. First and foremost, since this court's founding, this court does not alter established rules of law. Burke versus Toothaker, 1 Mass App 234 at 239, and this court is bound until and unless the SJC explicitly says otherwise to follow SJC decisions about hard objects. Commonwealth versus Vasquez, 456 Mass 350 at 356, and if the Commonwealth truly wanted to make a change of law, this court's decision in Commonwealth versus Dube, 59 Mass App, gives them a roadmap to do that, and they didn't do that. Moving into the merits here, Your Honor.
What's your best hard object, what's your best case that says that when police have someone under arrest, and they're going to search incident to arrest, they're not allowed to search the pockets?
Your Honor, I'm sorry.
Go ahead.
Your Honor, I think White actually speaks to that, which is the question here is not the ability to search the pockets. The question is the ability to examine the pockets. And White and its ancestry, such as Blevins and others.
I don't understand the difference between searching a pocket and examining a pocket.
If there isn't a sound distinction between one as opposed to the other, the items, the risk the item poses has to be obvious to the officer. And here, the Commonwealth has accepted the judge's findings. That's in their brief at pages 9 and 10. We accept the judge's findings. There is nothing here that suggests that anything in Mr. Johnson's pockets were indeed posing a risk. At transcript 16, we patted him down to make sure he didn't have weapons. There was nothing in that. The Commonwealth could have elicited from
So when a police officer is doing a search incident to arrest, why can't they start the search by patting to make sure there's no gun or knife, and then continue the search by looking in the pockets to make sure there's not something else that could be used as a weapon?
Your Honor, the item's nature has to be obvious. That's the missing link in the chain here, which is you can pat frisk someone before you put them in the cruiser, but if you
It has to be obvious to do what?
the object's character has to be obvious as a means to.
I mean,
Your Honor.
you have to have obviousness in order for the officer to do what?
The item's character, the obviousness of the item's character has to be to pose a threat to the officers of safety or a risk of escape.
Right, but the officer has to have obviousness before he can do what?
Obviousness before he can examine an object. That's
Examine,
the key
you mean,
distinction.
and by examine you mean just look at it.
Exactly, Your Honor. That's the key distinction here, which is that any item, it has to pose an obvious risk to the officer, and the officer has to be able to substantiate
What if an
that.
officer decides, I'm not going to start with a frisk. The first thing I'm going to do is make the guy turn out his pockets. Why can't you do that instant to arrest? I know that's not what he did here, but why couldn't you do that?
Your Honor, I suppose actually that the officer could ask to turn out the pockets, but the problem with that is that the risk has to be, and I apologize if this was not clear, a search incident to arrest, as on this record, has to be only for the purpose of disarming the arrestee or limiting their risk of escape. Here, we don't have anything in the record that suggests that Mr. Johnson is a risk to the officer or posing an escape. Yes, there's testimony in the record that he's nervous, but at hearing transcript 29, the officer doesn't ask Mr. Johnson, do you have any weapons on you or anything I should be concerned about?
Do you need extra suspicion of armed in order to do a search incident arrest? I thought once you had the arrest, you could do a search incident arrest, period.
You can do a search incident to arrest, Your Honor, but here the scope of the search incident to arrest is limited because we don't have any information about the nature of Mr. Johnson's warrant. So the search.
But isn't there a difference between the reasonable suspicion Terry stop cases where there's no probable cause to arrest and the officer wants to pat frisk for the officer's safety because at the end of the encounter, the defendant's going to go on his way. And if he's got a gun or a knife in his pocket, he could use it against the police officer, versus a situation where the defendant is under arrest for the outstanding warrant, and we don't know what it's for, and is going to be transported to the station in a cruiser, possibly alone with a police officer and may have something that could be used as a weapon. Isn't there a difference in those scenarios?
I appreciate Your Honor's concern that there's a difference, but here, like any other warrantless search, the Commonwealth bears the burden to justify it because warrantless searches are presumptively unreasonable, and on this record, there's nothing here. The Commonwealth, as I said a minute ago, accepts the motion judge's findings of fact. They are not asking for new findings, and in any event, they would have to demonstrate that the findings
What do we do with the
erroneous.
fact that at the hearing on the motion to suppress, defense counsel told the judge that the defendant wanted to waive the motion, and also that the defendant didn't file a memorandum? So how was the Commonwealth on notice that the defense was going to be arguing that a search of the pockets was unconstitutional?
Your Honor, I have a couple of responses to that. First, in the appendix, the defendant's motion, although I appreciate Your Honor's point, there's not a memo in support of that motion. I just want to get the page here. The defendant's motion at record 10 says, I am challenging the seizure of 17 bags of heroin. At the hearing, at hearing transcript 7, after that initial discussion back and forth, what are you doing with this motion? Are you waiving it? We're going forward. The Commonwealth says, Your Honor, I've had an opportunity to prepare. There are 6 references to the pockets, mostly at transcript 16 and 17, and again at 34. So I think any argument here, and I apologize if my brief was not clear about the bag as opposed to the pockets, any argument here about a lack of notice or ambush is not borne out. The Commonwealth had notice of this issue. The judge considered it. Everyone was aware that the question here was a search incident to arrest. So any arguments about this notice issue just are not borne out.
And the Commonwealth submitted a memorandum saying the search of the pockets was incident to arrest. What's your best case that says that the police can't search someone's pockets incident to arrest?
Your Honor, I don't know of a case that has framed it exactly as you've said it just now, but again, I fall back on White and Blevins and everything, saying that an object's character as posing a risk must be obvious to the officer, and the Commonwealth has to put on some evidence from the officer that the item's character is indeed obvious, and here there just isn't any of that in the record. Transcript 16 to 17, the Officer Carasoto is talking about how the search shook out. There's not a question in there about, officer, based on your training and your experience, what are the characteristics of a risk in someone's pocket? Hearing transcript 29, did you ask about weapons or anything? No. Hearing transcript 30, I had heightened concern because he was nervous. Transcript 33, I don't recall the packaging. Transcript 34, money in the pocket, it was not concealed. So I think the record here just does not bear this further issue out.
What if an arrestee had something in their pocket that was extremely toxic, like powdered fentanyl? It could be used as a weapon. Would that change your analysis?
Your Honor, a toxic substance could well change the analysis, but again, the Commonwealth bears the burden to show that it is toxic and it does indeed fit the search incident to arrest exception to disarm or otherwise to avoid a risk of escape, and the Commonwealth would have to put on some evidence about that, which I think they could do very clearly. Officer, based on your training and experience, what does a toxic substance feel like, or what are the risks it pose? In my training and experience, if this is powdery or crystalline, it's something along those lines. Officer.
And the Commonwealth would have known from the defendant's motion to suppress at page 10 that they needed to elicit that testimony from the officer.
That's precisely correct, Your Honor. Yes, the Commonwealth, this motion perhaps was thin, but this motion was enough. And if there were truly questions about this issue of notice, the judge could have asked for additional briefing. The Commonwealth could have filed a motion for reconsideration or otherwise done something saying we've been ambushed here.
Counselor, it seems to me, and I'm asking you because I could be wrong, that if, and it's a giant if, the officer was allowed to see the bags of heroin, then everything else is gonna be okay. Is that right?
If he sees the heroin, Your Honor?
Right, well, if it was legal, if his seeing the heroin was legal, and I know that's a huge if, but if that were the case, I'm trying to figure out what's really at issue then. Is it the case that everything else falls into place, then he's got probable cause to arrest for the drug possession and can look in the bag and can take the money?
I think that's absolutely correct, Your Honor, yes, which is if the officer could see the heroin or if there was something about the character of the heroin that correlated it to this exception, we wouldn't be here. Unless Your Honors have further questions, I ask that you affirm, and I thank you for your time.
Thank you.
Thank you.
All right,
And thank you, Your Honors, for your solicitude. I appreciate that.
thank you both. It's a really interesting case, and we really appreciate the briefing and the argument.
Sure.
Just a sec. Do we have Mr. Ryan? Is Mr. Ryan here?
Not yet, it's on his way.
Okay.
Want to take a break?
Do you have any reason to believe he's imminently here, or?
Working in Boston, he's working here in the city, and I texted him and told him that I was here, we planned to meet. I'm not sure if the traffic, or the weather, or his job.
All right, well, why don't we take our break then?
All right.
All right, in that case, we'll take our 15-minute morning break. Hopefully he'll be here
Okay,
by then.
okay, thank you.
Court all rise, please. This court is now in session. Please be seated.
All right, I understand we're still missing Mr. Ryan, is that correct? So we'll hear the next case and circle back to that if we have Mr. Ryan at that point. So sorry for the musical chairs, but we'll go on to the city case. We'll let everyone get hydrated before we start. All right, calling number 23P 1493, City of Boston versus Boston Police Patrolmen's Association. Whenever you're ready, Counselor.
Good morning, Your Honors. May it please the Court, my name is Kay Hodge, and with my partner, John Simon, we represent the City of Boston. This is a case of first impression because although there have been lots and lots of cases involving arbitration decisions arising out of labor disputes or labor contracts under Chapter 150C, this is a case that was fully confirmed by the Supreme Judicial Court and judgment had entered. Although the union has cited a number of cases in which that have gone up to the SJC back and forth, the fact of the matter is that except for one case, which is the Sheriff's 2 case, none of those cases had in fact been confirmed as this case had been. And nevertheless, the Superior Court judge thereafter reopened
But wouldn't
the
that
case.
mean, so the issue wasn't raised before the SJC as to the meaning of the word compensation? And I understand that point.
Correct.
But wouldn't that then just entitle the city to stonewall and just not pay what the claimant understands compensation to include? And there'd be no way to review it?
Well, Your Honor, this is the issue. This is much like the mitigation issue that was involved in the sheriff's case. And I believe that it must be, in fact, raised during the original arbitration. The fact of the matter is that what you're saying is that the arbitrator failed to adequately describe its procedure. But there isn't a procedure in the statute. And I would direct this court's attention to the most recent case decided by the SJC. Again, we're all responsible for following those SJC cases. And that is the case of the Boston Teachers Union versus the City of Boston, with the School Committee of the City of Boston. It is at 494 Mass 519, 2024. It was decided after our reply brief was filed with the court. In that case, the SJC reversed the Superior Court. The issue was not the same issue we have here, but the important part of that issue is this. The fact of the matter is that neither party had originally filed a motion to vacate or a motion to confirm within the 30 days provided for under Chapter 150C, Section 10, 11, and 12.
So the judge can't sua sponte remand to the arbitrator?
Pardon me?
The judge can't sua sponte remand to the arbitrator?
I don't believe that the judge should sua sponte remand to the arbitrator on a motion for contempt after the SJC has confirmed. I think that during the back and the forth of a case before that final confirmation, it is a different matter.
So what do we do with all those cases like Sheriff 1 and Pittsfield where the SJC said, well, we would have liked to remand this to the arbitrator for clarification, but the arbitrator's dead?
Well, that was Sheriff, yes,
Right.
where the arbitrator was dead. But that was before the SJC had issued confirmation and judgment had entered in the Superior Court. Your Honor.
So the
this-
SJC, even if this case were somehow in the SJC instead of
No, if the
here?
SJC got it, as they did in Sheriff 1 in the first instance, what did they do? They determined that they didn't have enough information, and therefore they remanded it back to the Superior Court for consideration. The fact of the matter is that that's always, before they confirm it and judgment enters, it's always open to the SJC to send it back. Had this issue been raised at any time during the approximately 7 years that the case was going up to the SJC in the first instance, had the issue of damages been raised. Now, I think that this gets back to a very fundamental question. When you have a case in any proceeding, and you ask for damages, you ask for a remedy, and indeed the issue presented to the arbitrators, was he discharged for just cause? If not, what should be the remedy? And the judge issued a remedy, albeit here, what's called a make whole, and that was unclear. Now, when you get to the lack of clarity of the particular issue, then at some point you should be presenting some evidence at the arbitration or at the original proceeding. In a number of cases tried before.
Regardless of that, the arbitrator decided that the officer gets any other benefit. So regardless of whether the arbitrator, the award says, make him whole for any other benefit. And so regardless of whether he should, we're stuck with that, aren't we? That's the award, any other benefit.
But the identity of those any other benefits was not specifically clear. Boston provided to the grievant in this case, not only back pay of $500,000.
It's not clear, so someone's got to figure out what it means. And maybe that's, like in Sheriff 2, the Superior Court judge, maybe that's, as what happened here, the arbitrator, but someone's got to figure out any other benefit means, right?
No, in this particular case, the parties attempted to negotiate, they were unsuccessful. I'm saying to Your Honor, the reason I cite to you the BTU case that was just decided, it basically required in that case that the city, in order to argue about what did the provision mean, it was a provision that dealt with 18, the city of Boston school committee had to hire 18 paraprofessionals. It wasn't about pay. But in that particular case, the parties were unsuccessful in arriving at an agreement as to what that clause meant. And therefore, the union, months passed, but there is no time limit.
So in BTU, the SJC said that the city's interpretation would leave those who have an unchallenged award with no way to have it confirmed by a court. So what if the city...
The SJC confirmed the award because there was no time limit on the award. The BTU case, what they said is basically, and the thing that I think is important is, Chapter 150C means what it says what it means. Unless there is a timely claim filed under 150C, essentially there is nothing more. What happened in that case is that the issue was whether or not the school committee had lived up to the obligation to hire the 18 paraprofessional substitutes. The arbitrator said it had not. So neither side filed within the 30 days.
So what do you say to the analysis of both the remanding judge and the confirming judge that under 150C, the award is imperfect in a matter of form, not affecting the merits of the controversy?
Well, I would direct your court's attention to a critical phrase in Trial Judge 1's decision, and that is, he dismissed contempt because contempt could not be an appropriate vehicle because the amount wasn't clear enough from the reading.
Yeah, I get that, but
then he said, quote,
Counselor, I don't understand
initial
why.
complaint,
I don't understand why, if there's not a contempt situation, if we say it was wrong to remand, why the union can't just file a motion to enforce the judgment, and then a Superior Court judge would have to decide what any other benefit was.
That wasn't the proceeding.
But the arbitrator, which I suspect at this point is going to say it includes back pay and back detail pay, And the only thing that will happen is you'll lose the fairly generous formula that the arbitrator created for determining what that was. Why is that not what's going to happen if we say the remand was improper?
Because, Your Honor, the critical issue, and if you look back at trial judge, and I could see the skepticism on your faces, if you look at the trial judge one's decision, what does he say? Quote, after dismissing the contempt, he says, quote, the initial complaint in this matter by the city.
So if he'd written his findings the other way, if he'd put dismissing the contempt at the end, then it would have been okay?
No, he dismissed the contempt, then he said, the initial complaint in this matter by the city, that was the city's initial motion to vacate and the union's motion to confirm, which remains the open matter in the present proceeding. It was no longer open. Judgment had entered. And there is law as well as the Massachusetts Rules of Civil Procedure 65A, I believe, which provide that that a contempt must be filed under the same number as the original case, but that it is a separate matter.
But again,
It
we've
does not
got a
reopen.
judgment of the court that the city has to pay the officer any other benefit.
I'm sorry, I didn't hear you.
Excuse me. We have a judgment of the court that the city has to pay the officer any other benefit to which he's entitled. Why can't the union file a motion to enforce that judgment, at which point a judge would have to determine what any other benefit means and could find that the arbitrator meant it to include back pay, back detail pay, and back overtime pay?
Because in this case, you have a confluence of both the res judicata issue as well as the last argument we make under White versus the City of Boston. It was this contract, by the way, Your Honor. It was a police officer under the contract with the Police Patrolmen's Association. And in that particular case, this court determined, and the SJC affirmed, was that details and overtime pay are too speculative.
But I don't know how you can take the position that the arbitrator's award is a judgment of the court affirmed by the SJC, and that you can say it was wrong to include that stuff because of these cases. How do those work together?
Because it was facilitated because it took a Superior Court judge's determination to remand back to the arbitrator to get the arbitrator to make that decision. I would juxtapose Sheriff's 2. In Sheriff's 2, the judge sitting on a contempt did not find that they could not figure it out. They nevertheless issued a ruling under contempt. Now, presumably that could have been subject to subsequent appeals, but the fact is that that was the mechanism under which that judge acted. Here, you have trial judge 1 acts on an open issue after judgment had been entered by the Supreme Judicial Court. You have the union arguing, oh, no. Anytime confirmation happens, there's always maybe other issues that occur. And cites to you cases that say that, and they're correct. They were just not SJC confirmations. In the one case that went up to the SJC for confirmation, which is Sheriff 1, in Sheriff 2, the judge was sitting on a contempt complaint and resolved it that way, and apparently no further, and found that that the obligation to mitigate had not been raised previously in the arbitration. The fact of the matter is that that's not our case. Our case is that the judge did not act on the contempt. The judge did not act, as Your Honor had suggested, on ascertaining, the enforcement of the...
No, I get that, and you're asking us to say that judge was wrong. And if we say that judge who remanded was wrong, I'm trying to understand what happens next, and I think what would happen would be a motion to enforce the award as written, and then a Superior Court judge would have to decide what that means.
Perhaps that would have been true, but Your Honor, at this point, note, there are a couple of issues. Number one, that the union argued for 5 different things: details, overtimes, leave buyback, and a payment of interest as well as a lump sum payment for taxes. The truth of the matter is they didn't get it all. So the fact that making it whole doesn't necessarily mean everything that the union necessarily believes that it should have had. And furthermore, what the BTU case says in 2024 was
Couldn't the judge on a
that the
motion to
legislature
enforce
should make that decision.
find those things were part of the award?
Pardon me?
If we have a motion to enforce where the judge has to decide for himself what any other benefit is, couldn't he expand it to include those things that the
I
arbitrator
don't
didn't
believe
find?
that you can expand when this court has said it is against public policy to grant speculative benefits, where the court is the
But
facilitating.
White wasn't an
entity.
arbitration case.
Pardon me?
White was not an arbitration case.
I'm sorry.
White was not an arbitration
It
case.
was not an arbitration case, but the the arbitrator in the first instance didn't say details and overtime. That just didn't happen. Here.
I have some questions for you about the record. I was looking for some numbers to try to figure out what we're talking about here in terms of money. And the best place I could come up with was at record page 213, where the arbitrator on remand says, on August 26, 2017, the city reinstated the grievant and was prepared to pay him approximately $502,225,000, representing his base wages, holiday pay, and shift differential retroactive to the date he was placed on administrative leave, February 18, 2011. However, the parties disagreed on whether the remedial portion of my award required certain additional components. Do you agree with that first sentence, that the parties
Yes,
agreed
we
and
paid
that he
it.
was reinstated?
It was paid.
Okay. I noticed that in the arbitrator's award on remand, the judge remanded for the purpose of considering the issues raised in the parties' memoranda. We don't have the memoranda in the record. Is there any dispute as to the scope of what the arbitrator was considering in those memoranda?
I think there is, Your Honor, and let me just say why. Because all the overtime is not guaranteed. I mean, people voluntarily choose to work overtime or not. It's the same contract. So if you read White, it was before an administrative agency. It was not before an arbitrator, but it's the same issue. There was no evidence presented anywhere in this record regarding whether or not and to what extent.
But my point is that when he remanded, the remanding judge, rather than framing the issue for the arbitrator, the judge said, consider the issues in the parties' memoranda. Do we need to get those memoranda to figure out what issues the arbitrator considered?
I don't believe so, because the arbitrator considered them and issued his ruling, and his ruling is in the papers, and I
Okay.
think that that's.
I have another question about the way that the arbitrator on remand computed the average of the 3 previous years of the claimants' detail pay, overtime, and vacation buyback. For some of those categories, the arbitrator used calendar years. And for other categories, the arbitrator used fiscal years. Is there a difference?
I don't know, Your Honor.
Okay.
I don't know.
Just wondered.
Can I just ask, what's the city's expectation with respect to the level of detail that an arbitrator needs to include in a remedial matter? Here, the arbitrator said, it's neither possible nor desirable for an arbitrator to scan the entire collective bargaining agreement lest every item that he believes might accrue to the grievant. So what's your position? What should the arbitrator have done in this case? Gone through the entire CBA and specify each item that was included?
I think the arbitrator should have said, I mean, if he was going to award details and overtime, he should have said details and overtime, particularly because of the existence of White and the existence of the town of Framingham cases. Those cases say that as a general matter, as a matter of public policy, it should not be ordered by a court or an administrative agency. Then if he is going to use the unique role of being an arbitrator to do something that the court itself could not do, then I would suggest to you, we ought to say, I intended it to be, details and overtime on an average basis or based upon whatever criteria the individual thought was appropriate. The same would be true for the
So
issue.
it's not legitimate for an arbitrator to say someone like Mr. Williams should be made whole for all benefits, right?
I
That's
think
just
that
not
that's a
appropriate.
shorthand that has been allowed to continue over time, but it is a shorthand that I think should not It does not necessarily, as it didn't in this case, the parties were not able to resolve how it should be imposed.
It's not an uncommon approach, though, in how arbitrators decide.
It
these
is
cases.
not, I would concede that it's not uncommon. However, the mere fact that it's common doesn't mean it falls within the sort of res judicata issue that we're raising, or that the legislature should not be asked to now define it, and/or the parties could agree through the collective bargaining process to agree to put a provision in the contract, presuming that it's lawful, to add it to the contract as to what would be paid in the event that this happens. After White and Framingham gave certainly the parties, the union and the city, knowledge that there was an issue regarding how to calculate the overtime due a public employee, and that there was a case of this court that said it was a violation of public policy for any agency or the court to issue that. To allow then a court on this circumstance, after an SJC confirmation, to now facilitate that an arbitrator could now clarify their opinion when there was no initial motion or complaint to clarify under Section 12 of Chapter 150C, filed at any time in this case, to have just decided that he was going to do it through that vehicle. Yes, does Section 8 allow the court to do that? It does, but I'm just saying, beyond that, Your Honor, I'm well beyond my time, and we will rest on our written submissions.
Thank you, Counselor. We'll hear from the union now.
Thank you. May it please the court, Attorney Alan Shapiro, representing the Boston Police Patrolmen's Association. I think the question that Justice Grant asked is really the fundamental issue here. What is the union supposed to do when the issue that was appealed after the arbitration award was basically about the reinstatement, whether reinstating Officer Williams violated public policy, whether it exceeded the scope of the arbitrator's authority? There was absolutely nothing in the record at that point concerning the contours of the remedy, the specifics of the remedy. The remedy was a very traditional, reinstated with back pay and benefits. It didn't go beyond that. And the construct that the city is laying out here is unworkable.
So what's wrong with my idea that you file a motion to enforce the judgment, and then a Superior Court judge decides what the arbitrator meant by any other benefit, and I have a suspicion what he's going to find, and issues it that way? Why isn't that, that's what happened in Sheriff 2, why isn't that the right answer?
Well, that could have been done here. If the trial judge won, I think he said it in his decision, that I think he could have decided the issues if he wanted to, but his choice was to send it back to the arbitrator. But it has to be decided somehow. I mean, the city, so they reinstated Officer Williams in August of 2017, shortly after the SJC decision and the entry of judgment. And then in April of 2018, he hadn't received a penny in back pay. So just
Do you agree with that sentence that I read from the arbitrator's findings on remand, that he was reinstated on August 26, 2017, and the city was prepared to pay him approximately $502,225, representing base wages, holiday pay, and shift differential, retroactive to the date he was placed on leave, February 18, 2011. Is that accurate?
Well,
It's at page 213 of the RA. I just want to make sure that he said you agreed on that part, you just disagreed on these other benefits.
he didn't pay them, and on RA 202, which is Trial Judge 1, he dropped a footnote, footnote 7, and this was issued as of July 20th. The city represented to the court in its July 2018 pre-hearing brief that at the time of that brief, a payment of $500,000 is currently being processed. That was the finding of the judge.
Right, but then the arbitrator had a footnote on his page saying it appears that the grievant has not accepted the city's proposed payment for the 500 and some thousand.
Yeah, I mean,
So my
I don't know. There wasn't, the grievant, it's not really up to the grievant.
Right.
Right? It's really up to the union. And there was no, offer by the city to say, okay, we'll give Officer Williams $500,000 and then he goes away and you guys sign off on that. That was,
I'm not suggesting that. I was just trying to sort of figure out the parameters of what's disputed and what's not. And it looks as though the way the arbitrator phrased it on remand is to say the city doesn't dispute reinstating him and they don't dispute that they owe him this much. We're only talking about the buybacks and the details and the whatever the other category was.
yeah, that's correct. I mean,
Okay.
the union didn't dispute the calculation of the back pay. And in that back pay award, they did include a couple of elements like holiday pay, shift differential. If I follow the city's argument, it seems like that would be it. That's what the union has to accept, because there's no avenue to contest what was paid. I mean, if they paid him instead of $500,000, if they paid him $50,000 or 50 cents, what ability under the construct that the city's setting out would the union have to challenge that? It's unworkable.
Well, I mean, there could be a contempt action in court, right? That's
Which is what we brought.
what you try, right? And here the judge says, well, I can't actually figure this out, right? But I don't think the city's arguing that's foreclosed. It just wasn't feasible here. Or maybe it was feasible and the judge declined to do
Your
it.
Honor, at the point that we filed the contempt action in April of 18, following the August of 17 judgment and reinstatement, he hadn't received anything in back pay. So although the trial judge 1 said, I'm not treating it as a contempt action, I think that was somewhat based on the fact that the city was representing that it was at least paying him his base pay with several other components of it. But it still was left open. What about the rest of the back pay award?
I'm having a hard time understanding how the remand order was valid. The last judge seems to say that there was something pending because the appeals court said that that the judge's own remand order contemplated further proceedings, and that therefore that was the pending thing, which seems like just strapping to say what was pending was my decision to remand. So I couldn't find a basis for the remand. What am I missing?
Well, I mean, I don't think there are any cases specifically on point as far as the mechanics of how it gets done. But I think if you look to the commercial arbitration statute, Chapter 251, I think we point out in the brief that there are several cases where this type of a process was followed, even though under 150C Section 8, in order to raise issues about the components of the award, the party's supposed to file within 10 days of receiving the award, which is obviously, possible. I mean, you don't even know if the city's going to appeal at that point. You don't know anything about the remedy. I mean, the appeals court, when they found that it was an interlocutory appeal, in that decision, they said that a dispute arose in 2018 over what the award should be, what the remedy should be. So, I mean, the court recognized, and all the paperwork that was filed here, minus the events around Trial Judge 2, and the arbitrator's second award, had been sent into the appeals court at that point, and they recognized that this dispute arose only after the underlying issue of whether Officer Williams should be reinstated and that portion of the award enforced. Only after that did we discover that the city didn't view the components of the back pay award the same way that the union did, with some precedent for that.
How is it possible this issue's never been decided before? I mean, this must, make-whole provisions, as I understand it, are fairly common in arbitrators' awards, right? And I would think in most cases you don't actually know whether there's a dispute until after 10 or 30 days. Has this never come up before? Have courts never addressed this issue? Have courts themselves, trial courts themselves, always handled the enforcement and not decided to refer it back to the arbitrator? Why is this a new issue? Do you agree it's a new issue, and why?
Well,
given all your experience in this area?
Okay. It's very rare that this happens. I mean, between these parties, as far as an arbitration case, I don't think there's ever been a case where the parties didn't agree on what the make-whole remedy consisted of. There were issues as I think Justice Grant pointed out, this is an arbitration award, not a civil service decision or a retirement board reinstatement like White. So we really, as a union lawyer for a long time, and Attorney Hodge, I think, matches me as on the management side, even though she looks younger than I.
Well said.
It's a rare, it's just something that, for the most part, it doesn't happen. So, especially in Boston, frankly. So,
well, if there were to be no avenue, like the city argues, does that then sort of impose on arbitrators a duty to really specify the relief and get away from these kind of generalized make-whole remedies?
Sometimes arbitrators, as the arbitrator in this case pointed out, Arbitrator Ryan, that sometimes arbitrators retain jurisdiction of cases for 30 days or 60 days, but they don't do it for like 6 years. I mean, they retain jurisdiction, and then if the parties are having an issue working out the remedy, then they go back to the arbitrator, and the arbitrator can clarify what they meant by the remedy. But here, there was no discussion about that because the whole focus of the city was on getting the thing overturned because they didn't think that the arbitrator had decided it. You know, they thought it was illegal the way the arbitrator had decided it. So it just didn't arise.
Wasn't there some attempt to bring this back to the arbitrator and the city didn't agree to that?
The union offered to do that. And actually, the city did not want to do that. And
cited some Latin doctrine.
Yes, fructus officio.
Okay.
I believe one of you, I've been reading the bios, I think one of you is a Latin scholar, but
Not me.
I went to Latin school, but I forgot more than I remember. But the fructus officio doctrine says that unless both parties agree, you can't go back to the arbitrator, although the judge did point out that that doctrine may be wearing away. So the union was perfectly happy to go back to the arbitrator.
Do you know if there's a difference between fiscal years and calendar years in the way the arbitrator calculated the
Some
buyback?
benefits under the collective bargaining agreement are conferred January 1 and others July 1.
Okay.
All right.
I just want to implore the court that there has to be some workable way of resolving these issues without, constantly having to go to courts again, arbitrators again. There has to be some path that will expeditiously resolve issues like this.
So do you think maybe the statute should be amended to provide a judge with a mechanism to remand to the arbitrator beyond the 10 days?
Well, I think if you look at 251 and some of the cases we cited, they've sort of fudged it a little bit, but they have basically allowed judges under an extremely similar statute to have that authority. So I think we either have to, interpret it that way. At least it makes it function. Thank you.
All right, thank you both. It's a privilege to hear from attorneys like you, and it's an interesting case. We'll take it under advisement. All right, so we will finally hear the Ryan versus Lovendale case. So before I start, Ms. Shepard, Mr. Ryan, have you decided who's talking, how much?
We're going to split our time.
Evenly?
Yes.
All right, great. All right, so calling Ryan versus Lovendale, number 23P 1365. Counselor, whenever you're ready.
Thank you. Good morning, Your Honors, and may it please the Court. My name is Masha Zilberman. I'm a staff attorney with the Family Law Project of the Mental Health Legal Advisors Committee. I'm joined here by our supervising attorney, Kate Niemans, as well, on behalf of the appellant mother. Your Honors, while this is a case of first impression, it is also a straightforward application of a very well-established principle. And that principle is that parents who face the loss of custody of their children to third parties have a due process right to court-appointed counsel. And that due process right has been established in all other types of third-party custody proceedings where these same constitutional principles are implicated. That's the case in guardianship proceedings, in care and protection proceedings, in termination of parental rights proceedings. And that is the case regardless of whether that third party is a non-parent individual or the state. There's no reason that parents who are at risk of losing custody of their children to third parties pursuant to Chapter 209C, Section 10D, deserve any less procedural protection than other parents in these similar circumstances. In this case, the appellant mother lost custody of her children to a third party, the paternal grandmother, with no counsel appointed. This custody award implicated her fundamental right to parent her children and violated her due process rights when no counsel was appointed.
When should the mother have been offered counsel, or at least informed of her right to request it?
Yes, Your Honor. Mothers should have been appointed counsel at the point where the court was contemplating awarding custody to a third party under the statute.
And that was when?
In this case, it appears that initially the custody award was contemplated and awarded pursuant to a temporary order in November of 2021. However, specifically with this appeal, we are seeking for the court to vacate the Rule 60B decision and remand the judgment.
Okay, but
I apologize, vacate the judgment.
when should counsel have been appointed?
Your Honor, counsel should have been appointed at the stage where the court was considering a third-party custody award.
And that was when?
Initially, the court ordered custody to the third party pursuant to a temporary order in November of 2021.
So in November 2021, your position is that's when counsel should have been offered?
Yes, Your Honor,
Right,
pursuant
so
to...
let me ask you this. If you agree to allow custody to a third party, are you entitled to counsel for that?
Your Honor, the statute, it depends, yes and no. The statute 209C, Section 10D, lays out very clear parameters. It states that if a parent provides written consent to a custody award, then no right to counsel. Then there is no right to counsel. I would say that there's then no right to counsel. However, if there's a fitness inquiry that proceeds, there is a right to counsel. Critically, in this case, we are while the statute does not differentiate between custody awards on a temporary basis or on a final basis, we specifically are seeking to vacate the judgment that ordered the final custody award to the third party.
All right, so if they don't get counsel for a voluntarily agreeing to provide, giving custody to a third party, then why would the November 2021, where the mother agreed to the temporary custody by the grandparent, be a point where she was entitled to counsel?
Well, Your Honor, my client did not, maintains that she did not agree to the custody award in November. I understand that the November order states that there was an oral agreement. Unfortunately, we don't have the transcript as part of the record. However, the statute is very clear that if there is consent, that it must be written consent. And I have seen at no point in this matter any sort of written consent suggesting that my client was consenting to the order. Further, the November...
Well, Judge Roberts' November 5th, 2021 order says, mother was not prepared for the pretrial conference, but filed a written statement requesting a continuance to obtain counsel. Do we have that written statement in the record?
I have not seen that written statement, Your Honor, but thank you. That's exactly what I was going to point out, is that on that date of the temporary order, my client did specifically indicate that she wished for the court to allow a continuance for the express purpose of her being able to retain counsel, which of course is tricky as my client is indigent and was not and continues to not be able to afford counsel in the matter.
Right, but in a hearing to decide whether mother or father should have custody, and where both parties agree that in the meantime, grandmother should have temporary custody, why is there a right to counsel for that?
Your Honor, if both parents had provided written consent at the temporary order stage, consenting to the third-party custody award, then I agree, there would not have been any right to counsel. What we're talking about here, though, is when the court was coming to the point of issuing a final judgment where they were pursuant to Section 10D ordering final custody to the third party and should have been making a fitness determination. My client was entitled, as both parents were, to counsel at that point.
That sounds like you're saying now that March 2022 was when mother was entitled to counsel.
Your Honor, our argument here is that mother was entitled to counsel in advance of the March 2022 judgment, but I do want to point out again that the statute 10D does not differentiate between custody awards based on a temporary basis or on a final basis the way some other statutes do. However, in this case, we are seeking for the March 2022 judgment to be vacated and for appellant mother to be appointed counsel prior to the case proceeding to a new trial.
Right, but how could she get appointed counsel in March 2022 when she doesn't show up?
Well, Your Honor, if the judge wished at that point to appoint counsel, or I apologize, if the judge wished to issue a final judgment that ordered final custody to a third party, then it should not have been done in mother's absence. If the court was contemplating such a final order that day, they should have adjourned the case, assigned counsel to mother, and had her counsel represent her at trial. A parent should not be defaulted when there is a fitness inquiry to be made. A fitness inquiry is a very, very serious inquiry. To find a parent unfit is a very grave standard. And
But then wouldn't that result in a situation where judges, as long as a parent never shows up, a judge is powerless to make a ruling?
No, Your Honor, and I do want to specify, we're talking about a very narrow circumstance here. We are talking about a case where in a custody proceeding, which is typically between two parents, where the judge is using this narrow portion of the statute, Chapter 209C10D, to state, we are not going to direct the third party to file a guardianship proceeding, which is what is typically done in the regular course, and instead we are going to bypass that and issue a third party custody award pursuant to Section 10D, where we are going to render the parent unfit. Additionally, Your Honor, to further answer your question, if the judge in mother's absence had at least made a finding of mother's unfitness, then I think we would be in a bit of a different situation than we are here. There was no unfitness finding made at all. And so in mother's absence, it's, I believe, be unfair to use mother's absence against her in that case where there was no prima facie case of fitness or unfitness made at all on that day.
But if she doesn't show up and object, then why can't the judge make a custody decision that's agreed to by the only parent who came to court?
Your Honor, because the right to parent is a fundamental right. It is a constitutionally protected right. Regardless of whether she was or wasn't present on that day, the court was clearly contemplating a final judgment of a third party custody award, given that they'd already issued that kind of order at the temporary order stage. So
how do we know that? That isn't clear to me at all. It seemed like we had a mother-father custody battle with just temporary custody being given to the grandparent in the meantime. How do I know that at any point before your client doesn't show up, the judge was considering a unagreed permanent guardianship by the grandparent?
Well, Your Honor, it's difficult to know what was in the judge's mind between the temporary order stage and the March 2022 final judgment. But again, if in the March 2022 final judgment, the judge was considering a final custody award to a third party, not through the guardianship mechanism, but through 10D, then they should have appointed counsel to mother and adjourned the case for a trial where she would have had the benefit of the right to counsel.
Okay, but how do you appoint counsel to someone who's not there? If you don't show up for a DCF juvenile court case ever, you never get counsel.
Your Honor, my client wasn't there that day because she had a medical emergency, and my understanding is she was present for all prior proceedings, including the proceeding where the temporary order was issued.
That's a good. What happened with that doctor's note that was mentioned at the hearing?
Your Honor, I was not, unfortunately, the attorney arguing at the hearing. I do not believe that that doctor's note is part of the record, though I do want to specify, as was indicated by the judge at trial, and that's in Record Appendix, page 60 of the transcript, the judge herself acknowledged that the doctor's note and whether or not it is or is not, present, does not actually have anything to do, it says, with whether or not appellant mother was entitled to have an attorney. And I think that that's correct. The fact of the matter is that this is a critical right that is constitutionally protected. It is a due process right that my client was entitled to. And that is the case regardless of the reason that she wasn't present. Though again, as she herself provided in the statement of facts that was in support of the Rule 60B motion, she did have a medical emergency that morning.
Can you tell us more about why it took the mother 13 months to file the Rule 60B motion?
Yes, Your Honor. It did take 13 months, as you point out, and I concede that that is certainly a delay. The record is unclear as to why it was so long, except there are a few things I want to point out, Your Honors. First, our client is indigent. She is a person with a disability. That's why she is a client of our agency in particular. This was a case that involved complex procedure, and she shouldn't have had to navigate that without counsel. I will state, as of January 2023, she was in communication with our office, and so any delay after that was certainly my fault, as we are a legal services organization, and we do our best to file things as timely as we can. So I filed that as soon as I could, but that delay after January is certainly on me and not my client. Prior to that, it's my understanding that my client was seeking legal services, which, as I'm sure your honors can appreciate, is extremely difficult, as there are very few providers and everyone is really overburdened. So my client, this was a complex procedure. She did not know how to navigate it without that. I will add, too, that I don't believe 13 months is sort of reasonably unreasonable under the statute. Rule 60B provides that for reasons 1, 2, and 3, cases are to be brought no later than 1 year, and then for subsections 4, 5, and 6 of that rule within a reasonable period of time.
It has to be reasonable either way, right?
I apologize?
It has to be reasonable under any of the 6, and definitely within a year for the first 3, right?
Yes, Your Honor, that is correct. And I will add, though, that specifically pursuant to Rule 60B-4, which is the subsection of the rule in question here, when there is a due process violation renders a judgment void, and a void judgment doesn't become less void just by virtue of the passage of time. And so when a judgment is void, it must be vacated, and it's said to be void from its inception. And our position is that in this case, the judgment was in fact void because it violated mother's due process rights for failing to appoint her counsel when there was a third-party custody award granted. And I do want to, I think, sort of the primary comparison that I think is critical to make here is with the guardianship sort of pathway, and that's what the SJC spoke to in guardianship of VV, and then followed up with the second case, the LB versus Chief Justice. And in guardianship of VV, the court likened the third-party loss of the third-party grant. I apologize. They likened the granting of custody to a third party and the loss of custody that a parent suffers to the same kind of loss of custody and the same due process rights that are implicated in care and protection cases, in termination of parental rights cases. And if you read the guardianship of VV decision and compare it to this particular statute we're talking about here, there are incredible similarities and very few differences in terms of the liberty interests.
Can I ask about the guardianship cases?
Yes.
One of the due process factors that the SJC considered in both cases, and LB in particular, is the Commonwealth's interest in ensuring that the children of the Commonwealth are protected adequately, and an interest in seeing that state resources are not used irresponsibly. And in LB, the court balanced those interests in the context of petitions to remove guardians by requiring that counsel be made available to those petitions that present a colorable claim for removal, but not for petitions that are obviously meritless. So is there any balance to be struck here if we were to agree with you that some right to counsel should attach to these proceedings? And how would we apply that balance here where, according to the other side, the mother made no effort to contact the court, to notify them of her failure to be present?
Yes, Your Honor. I think in terms of the balance to be struck, if I can first say, my understanding generally is that custody awards pursuant to Chapter 209C, Section 10D are quite rare. And I think CPCS in their amicus brief speaks to this. It's their understanding that there are only a handful of such cases a year. And I think the obvious reason for that is that typically when a third party is seeking custody, they are directed to file a guardianship. And in that context, parents are certainly afforded the right to counsel. Secondly, Your Honor, yes, in LB they do talk about there needing to be a meritorious claim. LB focuses specifically on petitions to remove guardians as well as petitions to modify guardianships. What we're talking about here, and what I think is akin to guardianship of VV specifically, is that we're talking about an initial petition. We're talking about an initial awarding of custody to a third party. And so I think that taken together with the infrequency of these cases, taken together with the critical nature of this due process right, would sort of, I think, render it necessary to just have a sort of blank.
Across the board, no exceptions.
Across the board, no exceptions. In the rare circumstance, again, we're not talking about a wider case of custody. We're talking about these rare circumstances where the court is contemplating a third-party custody award specifically pursuant to 10D.
I'm confused by the word contemplating, because was the judge supposed to think at that November, I think 2021 hearing, oh, I bet you this mother's not going to show up next time. I better appoint her counsel because I might end up giving custody to the grandmother. What do we tell probate judges they should do when they contemplate?
Sure, Your Honor. And I think there is a case that speaks to this. It's an appellate court case from 1995, Balboni via Balboni, and it specifically talks about a judge's contemplation of custody of a child to then DSS, and that it's that contemplation of custody triggers the right to counsel. And so I think this is sort of this contemplation of custody is something that has been talked about before. I would say that if the court was contemplating, in other words, if the court was considering custody to a third party, they should have adjourned the matter and assigned counsel in the meantime. It's not that the court should have known that a certain litigant was or wasn't going to appear at the next hearing. Certainly they wouldn't know, and that's not the inquiry. But I think if they're considering in this limited circumstance using the statute 10D for a third party custody award, then yes, I think the proper mechanism would be to appoint counsel and then adjourn for reasonable sort of continuance for that counsel to have time to consult with the client. And I apologize. That's my train of thought.
Well, you're over time. Any questions?
Oh.
All right. Thank you, Counselor.
Oh, yes, thank you.
You looked like you got another sentence to say, so go ahead.
That's okay. I just wanted to say, Your Honor, thank you. I just wanted to, in summation, say that there's no reason that parents pursuant to 10D should be treated any differently than parents in guardianships in these similar cases. And so I hope that you're able to consider that and find that there is, in fact, this due process right to counsel for parents under this subsection. Thank you.
Thank you, Counselor. All right, Ms. Shepherd?
Hello, I'm Ann Shepherd. I am the grandmother of Michael, Tyler, and Charlie. Michael and Tyler first came to me when Michael was 2, Tyler was 1. It was before Charlie was born. Rachel, their mother, went into a drug rehab up in Maine and never came back for 9 months. She was away for 9 months up there working, would occasionally come to visit. When she did come back, she got pregnant and had Charlie. Charlie came to me when he was just around 2. Twice, I think, DCF took him and asked me to take him, which I did. They really haven't ever left my house. My son lives with me. They lived with my son for about a year or so in their apartment and then came back to me. I just wrote, my argument is in lay terms, and I wrote this last night. The first thing, one thing I want to say is her disability, I'm not sure what it is. She works, she drives a car, she's out and about, she travels, so I'm not really sure what her disability is. I know she collects Social Security disability, and she told me that the boys are entitled to benefits under her, which I just started to receive from Michael. When I checked into Social Security, I found that Rachel was receiving Tyler's benefits. She has received over $1,000 this past summer that was earmarked for Tyler. Anyways, this is what I wrote. In my opinion, Rachel Lovendale should not be granted reconsideration for another hearing. Rachel continues to use drugs and in the very near past has purchased drugs while she was with the boys. Rachel was evicted from her 3-bedroom apartment in Whitman because she lied about having custody of the boys. The apartment was a low-income apartment provided by Whitman Housing. While Rachel was living in this apartment, she had many 911 health and welfare checks by the Whitman police. She also suffered at least 1 overdose where CPR was performed. Rachel has on numerous occasions shoplifted while she was with the boys. One time at Walmart, another time at the gift shop in the Science Museum. Rachel collects Social Security and has claimed that she has custody of Tyler, and I already mentioned that. She's currently under investigation by the Social Security Department. Rachel does not pay child support. She does not contribute in any manner to their well-being. Rachel has not met their teachers, seen their report cards, or is in any way involved in their schoolwork. Rachel has visitation on Saturdays from 10 till 8. She is habitually late, having no regard for anyone else's schedule. Recently, she was over an hour and a half late. When I approached her about this, she became confrontational, which is generally the case with her. Later, the boys came home and told me she called me the C word and an old hag. The boys are 7, 10, and 11. Is this really the way a mother should talk? Never mind the fact that I'm their grandmother and I have been raising them for more than half their lives. The boys are safe, all together, happy and healthy. They do well in school, they have lots of friends, and they play sports. They are participating members of the Catholic Church. They go to CCD and have received the sacraments they're old enough to receive. In my opinion, this request for an appeal is groundless. This has been going on far too long and appears to be a never-ending cycle. We are frustrated and tired of her excuses and her shenanigans. She is rude and disrespectful to all of us. And also, I don't think she takes advantage of the 10 hours that I actually told the court she should have when she didn't show. They said, what do you want, And I said, why don't we let her see them from 10 o'clock on Saturday morning till 8 p.m. on Saturday night. She doesn't take advantage of that time that she has with them. She's late, or she doesn't show up, or she has to work, or she doesn't have transportation. So I don't think it's beneficial to anybody especially to the boys, for her to have more time with them. I don't believe they're her priority.
Thank you. I unfortunately have to tell you that regardless of what we do, the mother can at any time move to revisit the custody decision, where if there was going to be an order placing with the grandparent, a finding of unfitness would have to issue it at that point. So no matter what we do, it can't really be over in that sense, I'm afraid.
I understand. I just wanted you to have a little background information. Thank you.
Good morning. Thank you
Morning.
for waiting this morning or earlier. So I am, I'm nervous. So I am their father, and, you know, when I first met Rachel, like, she was a hairdresser, she drove an Audi, you know what I mean? Like, I thought I hit the lottery, so, again, with the disability, I'm not really sure what it is either. Once we started having children, things just went downhill for both of us, and then anytime I was in contact with her, I felt like it was another way of her to try to get the kids, was she would, you know, say that a domestic disturbance happened, so I would go to jail. That's how Grandma ended up getting custody of the children in a way. But we live in Plymouth. They go to the schools there. Rachel could go there anytime she wanted. She could have the last 10 years. She doesn't. She only goes on her days when she's, you know, allowed to. But it's not like she ever calls and says, hey, can I come over and do homework with the boys? Or like, can I bring them to hockey practice or anything? She doesn't do that. It's not, I mean, she just doesn't do that. So I understand you judges are not the ones to have that argument in front of, but this is like a big waste of time. I mean, you have to do it's just a pain. I don't know. I don't know if I'm making much sense talking, but if this gets kicked back down to the probate court, again, because the appeal was overturned, now it just starts the whole process all over again. And nobody likes courthouses, you know? Nobody wants to go to court. We're sick of going to court. It's the same thing. And as things go on, things just get worse. It's not like we're going to go back to court and they're going to be like, wow, she turned the corner. She's been driving them to school. She bought them all new clothes. No, it's going to be, nope, she still hasn't seen her kids. Nope, doesn't know their teachers. Nope, you know, doesn't show up on time. Still doesn't have a car, no job. Come on, why are we here? More or less. So that's that. Am I supposed to go till this ends? I don't know what else to say.
Absolutely not.
No.
I'm trying to just
It's just the opposite. It's to make sure people don't go too long.
Yeah. So
If
yeah,
you've been-
that's
if
how
you've been
I
there before,
see it.
there were
I just
definitely-
see it as a big nuisance, and then I see it as her seeing a loophole, like, oh, wait, they didn't offer me an attorney. Oh, we can file an appeal. We can prolong this even more. That's kind of all it is, to me, in my eyes, from knowing her. Because the effort, it's just not there. Her effort as a mom is not there. Not even on the days when she has them. So, she loves them, obviously, but I think what she wants initially, I don't think she can provide. And the kids are at the best place where they could be, at my mom's house, where she's retired, and she can get them to school with my stepfather and all that. Like, we have a big team going on there. You know, I'm able to go to work every day while they do that, other things. Then I come home, and then it's the homework time, then it's hockey, and then it's whatever it's gonna be, showers, all that stuff. And, I don't know. I don't see her, what's she gonna do? She's gonna get him and then go where? She can't, what are they gonna do if she gets sick? She's gonna drive him to the doctor, take an Uber? Her stuff is just not in order. Neither is mine that good, but it's better than hers. And that's that. So I guess I'm done.
Thank you.
All right,
Right,
thank
thanks.
you. All right, thank you all, and we'll take this under advisement. We'll let everyone exit. All right. I'll call the last case of the day, number 24P55, Privileged Underwriters Reciprocal Exchange versus HILINSKI. HILINSKI?
Linsky.
HILINSKI, thank you.
You're welcome.
Whenever you're ready, Counselor.
May it please the court, good afternoon, Your Honors. James Crowley on behalf of Scott, Lisa, and Callie HILINSKI. I'd like to start by reading a sentence from Pure Insurance's brief in this case. In the last paragraph, they say, if the named insured on the policy had wanted more coverage for underinsurance, he could have purchased more coverage. Well, in fact, that's what he did, Your Honors. My client, Mr. HILINSKI, and his family were insured by an in-state insurer for many years with a standard Massachusetts insurance policy, but in about 2015, they decided to upgrade their coverage and purchased a supposedly high-end policy from Pure Insurance that included a primary policy and an excess policy. The primary policy had $250,000 in liability and underinsurance coverage limits, and the excess policy had $10 million in liability coverage and $1 million in excess underinsurance coverage. On March 30th, 2018, young Callie, who was just about to turn 16, was riding in a golf cart owned by her father in Hyannisport, being driven by a friend, and the vehicle overturned. And she suffered a terrible knee injury for which she's had 4 surgeries and is having a big one coming up, and is being told at 22 that she'll need a knee replacement in 5 years. We submitted a claim to Pure Insurance. They offered the $250,000 limits on the primary policy on behalf of the driver, Ms. Conley, and they declined and denied the rest of the claim. They denied the $10 million excess liability policy coverage, and they also denied coverage.
What do we know about Conley's insurance status? I didn't see it, but maybe I missed it.
I don't think it's in the papers, Your Honor. We did pursue what was available there, and her insurance, her family's insurance company did provide coverage under her policy limits, or family's policy limits, which were $100,000. So she has received that, Ms. HILINSKI has. But Pure denied the rest of the claims, and our position is that the policy of the state, as we discuss at length in the brief, in the very complicated and comprehensive motor vehicle insurance laws, are to promote full compensation when possible for people, and also to encourage residents of the state to properly insure themselves. And that's what Mr. HILINSKI and Mrs. HILINSKI did in this case. They bought a large amount of coverage to protect themselves from liability, but also to protect the public from any incidents that they would cause. And in addition, they purchased a large amount of coverage to provide protection to their family if they were injured by an underinsured or uninsured motorist, $1 million in that case. And now we come to a situation where the insurance company is saying that neither coverage is available. Now, we're making a claim in our brief for both excess liability coverage and underinsurance coverage. The excess liability coverage argument is pretty simple and straightforward. It's a contract. The language of that contract has an exclusion. We believe the coverage applies. It's therefore Pure's burden to prove that an exclusion applies. The exclusion that they have stated is in the excess policy. It says that no damages will be paid for family members.
And no court in Massachusetts has ever addressed whether that exclusion violates Massachusetts public policy.
I think that's right, Judge Toone. HAN does address a homeowner's policy, but it was not an auto claim. So our position is that HAN makes a comment that no statute applies. Our position is that the motor vehicle laws of Massachusetts apply in this case and create a public policy that's very clear of full compensation. There's a minority position in the states that supports our position. Admittedly, it's a minority position. There are 3 states that basically say, similar to Massachusetts, their state's motor vehicle insurance laws promote full compensation, and therefore the term in this excess policy that they consider in those 3 states is inappropriate and violates public policy. That's our position there. It's pretty straightforward.
Okay, so let's set that aside
Yeah.
and focus on the excess
Underinsured.
UIM
Yes.
coverage.
Yeah.
And I guess, as I understand it, your initial argument is that the follow form provision doesn't apply here because it only applies to underlying insurance, and that's defined as liability insurance, and therefore the limitation or exclusion, whatever it is, that exists in the auto policy as it applies to UIM coverage isn't included in the follow form provision because that only applies to the auto policy liability provisions. Is that correct?
That's pretty close to what we're saying.
Okay, well, let's get exactly.
Well,
what
but
am
it's
I
very
missing?
complicated, Your Honor. I'll remind us all about that line in Carden from '85 that says that delving into motor vehicle laws in Massachusetts is like driving the streets of Boston,
Yeah.
right? And
we can agree on that.
I'm gonna, yeah.
What specifically is your argument that the follow form provision
Yeah.
doesn't apply here?
So our position is that the claim is covered in the first instance under the excess policy, and therefore Pure has the burden of proving that there's an exclusion. Pure says that the policy, the excess policy, says that the UIM coverage, underinsured motorist coverage, will follow form to the primary policy. We say there's a number of reasons why that doesn't work. First, as you point out, that the definition of follow form in the policy says that it applies to liability, underlying liability insurance. And in the excess policy, there's a couple of other places where it's made very clear that they're talking about liability insurance, which is not the same thing as underinsurance.
Isn't Conley's insurance liability insurance? Isn't that the underlying insurance, Conley's?
Well, as to the provisions in the excess policy, Your Honor, the follow form terminology is referring to the primary policy of Pure. Now, we've collected $100,000 for Ms. Conley. That's an offset against any potential damages, but that's not the primary policy. At least we haven't argued that. Now, if that were the policy that was at issue, then that brings me to one of our primary arguments here, which is besides the issues with the follow form provision, which we think are ambiguous, the next sentence after underlying liability says that the similar provisions are superseded in the excess policy, which I cannot see how the two concepts can be put together.
Let me just stick on this before
Yeah,
we get away
go
from
ahead.
it. So, right, so you're first on the follow form, it's just liability insurance, and the auto policy's UIM coverage isn't liability insurance, right?
That's one of our arguments.
The second sentence is supersede, and
Yes.
you're just like, well, that only helps our position, right?
I believe so.
Okay, and then the third sentence is, will not provide broader coverage than the underlying policy. Now, what does that mean?
Well, I think what it means is that if you're following form, then whatever limitations there are in the coverage in the primary policy would have to also, apply in the excess policy.
So then if there's no coverage under the underlying policy, then there's no coverage under the excess policy.
Well, that's exactly what Pure is arguing, yes.
Okay, and why is that wrong?
Well, we say it's wrong for a number of reasons. First of all, that it's ambiguous because the follow-form provision refers to underlying insurance, which is defined. Our position is that does not include liability. There are cases in Massachusetts that we've cited that say that liability insurance.
But we will not provide broader coverage than the underlying policy. Just that issue right there. Why is that not a barrier for you?
Well, because in the underinsured coverage provision, it says coverage will follow form. When you look at what follow form means, it includes the paragraph that has at the end of it. I'm just saying, if that was the only thing it said under follow form, then the argument might be better for Pure. But it also says that it applies to underlying liability insurance, and it says that the similar provisions will supersede. So my position is, at the very least, it's ambiguous. But then,
well, say we read that to mean you can't get any more coverage than you get under the auto policy. What would be the point of the excess policy in that case? If this follow form provision applied and said you can't get any more, we not provide broader coverage than the underlying. But what is the point of the excess policy at all?
Well, it's a good point, Your Honor, and there are a number of arguments made by Pure that seem to suggest that you couldn't really have any. But the point is that the underlying policy, it differs from the standard mass policy, which would be the policy Judge Ditkoff just mentioned that covered Ms. Conley. It does not have the exclusion that Pure is relying on here, that exclusion in the primary policy that says that an uninsured motor vehicle cannot be a motor vehicle owned or regularly used or provided to a family member. That is not in the Massachusetts standard policy. It's not in 113L. So in addition to our argument is if you find that it isn't ambiguous and that follow form does apply to the excess policy, our position is the provision that they're relying on to exclude coverage here is illegal.
No, I get that as your secondary argument. I'm just trying to understand your primary argument that the follow form provision doesn't, that you win because that doesn't apply to this case. And your essentially is, yeah, that last sentence seems to be harmful to our position, but maybe it's ambiguous.
Well, taken as a whole, the paragraph is very ambiguous. It applies to underlying insurance and provisions that are similar will be superseded. So who cares? Our position is who cares what the last sentence says, because you don't even have to get there. But if you do get there, I don't think there's any way for this court respectfully to find that the exclusion that's in the Pure primary policy is not contrary to 113L. It's just spelled out very clearly.
So this is the owned and regular use exclusion.
That's right.
Exclusion.
That's right. Which is what they've relied on from the start to exclude this claim. And just like Cardin Court said that the streets of Boston are analogous to this type of law, in '88 the legislature changed the UIM statute, the uninsured motorist and underinsured motorist statute. And what they did is they cleaned up the stacking problem, but the trade-off that was made is you can't go to more than one policy, but you will always be able to go to at least one policy and one policy only if it's a motor vehicle injury. So the Cardin case talks about if you're sitting on your porch and you get hit by a car, there's going to be a policy that you can go to. And in this case, Pure is saying, no, sorry, there's no policy you can go to. And if, as Judge Ditkoff pointed out, if the primary policy was, and we'd be happy if the court considered the primary policy in this case to be Ms. Conley's standard Massachusetts policy, if you went to that policy, you would not find this exclusion. The reason you would find...
but doesn't the contract say that it would be if we had sold the underlying policy, which would have had the exclusion?
Well, Your Honor, I had never thought of considering the Conley policy the primary policy. So I believe that the appropriate analysis is that the Pure policy is the primary policy being referred to. So I would agree with that. But my argument is that you cannot enforce the exclusion that's in the primary policy because it's the only place it exists. It's not in the standard Massachusetts policy, because it's not in 113L, and the standard Massachusetts policy follows 113L. I've included in the record in my argument the commissioner's materials from 2012 when Pure came into the state and asked for permission to sell these policies. I've provided the information in my...
How does that help your position? I mean, like the commissioner of insurance signed off on this, right? I mean, they didn't. You're saying they didn't identify this exclusion when they went to the commissioner of insurance?
Well, I can see that the commissioner approved the primary policy. I believe that he or she, I don't remember who it was then, did it incorrectly based on being misled by Pure, because when you look at the materials, I mean, what I think is incontrovertible is that the cases repeatedly say that you cannot vary the coverage that's spelled out in 113L. If you do, it's illegal, it's unenforceable. That's what Cardin said, and that's clear. So what Pure did is they come in and they have this different policy from the standard one that includes this owned or operated intra-family exclusion, and they say in their materials to the commissioner that they check boxes saying we are complying with this, including they list there are two exclusions that are in 113L.
So right, your argument is essentially that the two exclusions that the legislature added to 13L are the only ones allowed?
That's correct.
And that any deviation from the standard policy is invalid. Is there any case that says that, or we have to?
Well, Cardin's clear. The Cardin court would not enforce a regular use exclusion. The standard regular use exclusion, which says that if you are in a vehicle that is not on our policy, you can't have coverage under that policy because you haven't paid a premium under it, okay? That's a standard exclusion that's been upheld over and over again, pre and post 88 changes and so forth. And there are cases afterwards, Chenard and other cases that say that if the exclusion is not in 113L, that it cannot be enforced. I think that's pretty much black letter law. And so what I'm saying is when you analyze 113L, it says very clearly that if you're hurt in a car accident and your claim is underinsured, you will have a policy to go to. Okay.
Privilege cites Liberty Mutual versus McLaughlin, right, 1992 for the
Which case is it, Your Honor? I'm sorry.
Liberty Mutual versus McLaughlin for the proposition, 1992. For the proposition that the general prohibition against exclusions in 113L doesn't apply to optional excess policies.
Okay, yeah.
So what's your response to that?
Well, my response to that is that if they had spelled it out properly, they can do what they want in the excess policy, but they're relying on an exclusion in a primary policy that is illegal.
Let me see if I get
enforced.
Make sure I get that straight. You're saying if they had said UMI, no family exclusion, but for the getting to $1 million, there's a family exclusion. That's the distinction you're drawing?
Yes, if it had been in the excess policy, clearly and unambiguously stated, I think that under the McLaughlin case, since it's optional insurance, it can be enforced. But since it's in the primary policy, our position is that it's illegal, it shouldn't have been there, and it can't be then imported into It can't then be imported into the excess policy, and at the very least, it's ambiguous. I mean, we don't think you get to the policy in the first place because of the ambiguities in the follow form provision, but if you get there, they're relying on what is an illegal provision.
I understand you're saying that your clients thought they were buying gold standard insurance. What do we do with the fact that the page about the golf cart, RA 69, does not include any coverage for underinsured motorists, even though the pages for the Land Rover and the other vehicles, the Cadillac Escalade and the Mercedes, all do?
I think the answer to that question, Your Honor, is that we're talking about the excess coverage. And when you look at the excess policy, they don't list vehicles. It just says you have underinsured coverage if there's a limit listed for that, and there is a limit listed for that. So it doesn't matter what vehicle is involved. Could be a family vehicle, could be a friend's vehicle, whatever it might be. The excess policy isn't tied to a particular vehicle.
All right.
All set? Thank you, Your Honor.
Very complicated. Thank you. We'll hear from the company now.
Thank you. Good afternoon, Your Honors. May it please the Court, John Donovan on behalf of Pure Insurance. We're here today asking you to affirm the decision of the Superior Court that indicated that Ms. HILINSKI was entitled to receive $250,000 in liability coverage, but there is no additional coverage under the umbrella. As you're aware, we're talking about two different insurance policies, the auto and the excess.
You said you call it an umbrella instead of excess policy?
I think I'm using...
Are they synonymous terms? I literally want to know.
I think they are, Your Honor. Excess, umbrella, personal umbrella, I think they're all synonymous.
What's the point of getting an umbrella policy if it doesn't cover it doesn't give you extra coverage for something like this?
Well, it gives you coverage for a heck of a lot of other things, Your Honor.
What?
Including if she was a pedestrian on the sidewalk and had been hit, she'd have coverage up to the full amount. If she had, it was in another vehicle, not family-owned, she would be covered.
The coverage was $10 million for the outside world and $1 million for your own family, right? Isn't that the two coverage levels for the excess policy?
That's right. That's because she was injured in a family vehicle. And these family vehicle-owned exclusions really are tied so that people can't double dip under the same policy, which is what they're trying to do. She's entitled to the primary $250,000 liability limits, but she can't then double dip and get.
Why is it double dip? They bought two policies. They won two recoveries. I don't understand double. That seems like I mean, it may not. You may be right that they don't get it, but
Right.
sort of they're buying an extra policy here, so they get extra coverage.
Right, but they get extra coverage in very specific circumstances, and they don't just get it for everything. We've got to look at, that's why we have language of an insurance policy. It provides a great deal of coverage if she was a pedestrian or if she's in any other car other than a family-owned vehicle.
I want to drill down on that. If Conley had been driving Conley's own car,
Correct.
then what happens?
Then we compare the limits of the policies, and she would have $100,000 in liability limits, and there would be $250,000 under the primary policy, so she'd get $150,000 under the pure primary limits, and then potentially another $1 million under the umbrella or under the excess policy. But that's in a circumstance where it's not a family-owned vehicle. And the whole concept of that is, as it is illustrated in the case law, is when we're talking about underinsurance.
But that the family-owned exclusion applies to the excess liability under the excess policy, correct?
It actually applies to both. It actually applies to both. So, and this is well established under the case law. There's two reasons why she can't get, in this case, Your Honor, why she can't get underinsurance under the primary auto policy. The first is, of course, that the limits are equal. She's got $250,000 in liability coverage under the primary auto, and the limit of underinsurance is $250,000, so she can't get.
Wait a minute, just before you get down.
Sure.
The excess policy's exclusion for injured family members does not apply to underinsurance motorist coverage. Isn't that correct?
You've got that right. That's on the excess liability portion. The exclusion 14 that you're talking about is what bars coverage for the $10 million in excess liability coverage.
No, the exclusion does not apply to coverage provided under excess insured / underinsured motorist coverage. So it applies to that. It says it doesn't apply to UIM coverage.
That's exactly right.
Okay. So then why do you say it forecloses, the family exception forecloses UIM coverage under the excess policy?
Sure, because then if you go to the underinsured provision, it says specifically that we're going to follow form with what's in the primary policy. It says that right in that section.
So even though it says that it's excluded, then you say, well, the follow form, you go back and it's back there.
It's a different exclusion, Your Honor. It's a totally different exclusion. The language, and this is where it gets confusing. Exclusion.
It's already confusing. I don't, but why you have this very clear statement, this exclusion for the family exclusion doesn't apply to UIM coverage in the excess policy, but say, well, in fact, it does.
It's a different exclusion. The family member exclusion, exclusion 14, says we're not covering you for any personal injury for individual family members, okay? Household members. There's an exception to that for the underinsurance section, okay? That's that on the excess. In the underlying policy, the auto policy, the exclusion that bars coverage is the owned automobile or regular use exclusion. Because Mr. HILINSKI owned the automobile, and there's no debate about that.
Oh, I understand that. Okay, I understand. So the regular use is different from the family.
That's exactly right.
Okay, so we're just talking about the regular.
It's really, I'm sorry, Your Honor.
So, okay, I think you're kind of, or I'm confusing in my mind, but like the family exception, let's take that out. We're just focused on excess UIM coverage under the excess policy, right? And the first step is the follow form provision, right?
That's right.
Now, tell me, because it seems like a problem for you, you call it a red herring, but I don't understand why in your brief.
Sure.
The definition, the follow form says, defines underlying insurance as all liability insurance providing coverage, right? And so liability coverage, that goes to the bodily injury policy coverage under the auto policy. But it doesn't go to UIM coverage under the auto policy. So why does follow form incorporate the terms that apply to UIM coverage under the auto policy?
Sure. I think they're trying to torture the language to try to create an ambiguity here. If you look...
It seems not ambiguous. It seems against your position.
No, because if you look, Your Honor, first off, the follow form language is actually embedded in the underinsured language in the umbrella policy. It's right there in the policy where it says under the underinsured section, it says we are going to follow form. It says it right there.
Yes, and then it has a whole paragraph as to what that means. And the first sentence is, doesn't apply, it applies to all liability insurance providing coverage for damages that are not covered by this, by this policy, right? And liability insurance is defined to be, liability insurance and not UIM coverage. So why isn't that a problem for you?
Actually, I don't think the policy says liability does not include underinsured. It does not say that. What it says is underinsurance means all liability providing coverage for damages that are covered by this policy, and then it goes on to say it doesn't include this policy. If you look at RA, the Record Appendix, page 104, where it lists what the underlying liability insurance is, the underlying exposures, right there it goes through all the homeowner, and right there it says underinsured motorist protection. That's why I say they're torturing the language. Clearly, the underlying insurance includes all of these things listed in the underlying exposures, underlying limits on page 104 of the exclusion. Of the policy. It's right there. So, and I think, Your Honor...
But it also defines underlying insurance as all liability insurance providing coverage, right?
It does, but I think clearly what they're talking about is they're talking about all underlying insurance, including all these that are listed on page 104. And again...
If they said that, they wouldn't say liability.
Well, I don't... Liability isn't a defined term, Your Honor. It's not a...
You could go with an ordinary usage of it.
Would include in this concept certainly all of the underlying limits of liability, as they say on page 104, which says underinsured motorist protection. It says it right there. And I think, again, if you look at the policy in the underinsured motorist section, it says we will follow form. It says it right there. So we've got to ignore that language and say, well, they didn't, when they put it in the underinsured motorist section of the excess policy where they say we're going to follow form, we've got to ignore that and say, no, they didn't mean...
But we're trying to interpret the follow form provision. We're trying to interpret that language in your policy. And that's what's giving rise to this problem. At least it's an ambiguity, which we would normally construe against the insurer, isn't it?
Well, I guess in normal circumstances it would, but I don't think there's any ambiguity at all that the follow form means we're going to go and look at what the underlying policies are, and they don't debate or dispute that the underlying policy, the underinsured provision, doesn't apply in the primary policy because the limits were equal.
Let me ask you what I asked your friend, which is, for the UMI purposes, why isn't the underlying insurance Conley's insurance?
Well, because if you look at, it would include both, Your Honor. I think he said it would only include Pure's, but I think it actually could be both, because when they talk about all liability insurance providing coverages for damages, it could include both Connolly's and ours. And clearly, when you look at our policy, the underlying insurance, the automobile policy, does not provide uninsured motorist benefits to them, because not only are the limits equal, but they have an exclusion for owned vehicles, and there's no debate that Mr. Hilinski owned the vehicle.
What if Conley had stolen the vehicle?
Well, then you're going to get into issues of consent and authorization. You'd have to look at the provisions of the policy. I think there...
Well, I don't know why the exclusion wouldn't apply, because it would still be owned.
I think it probably would. I just don't, I'd have to look, Your Honor, to see whether there is also an exclusion where the vehicle is being operated without consent of the owner. There might be a specific
So
exclusion.
why is that a legal UMI exclusion?
Right.
To exclude anything owned by the underlying insured, even if it's being stolen, they're being driven, they're being run over while it's being stolen?
Sure. That is legal under mass law, of course, because you've got to understand what the real purpose of this situation is when you've got the unique circumstances of a family-owned vehicle being the only vehicle involved in the collision. This is a very unique set of facts where you're going only up against one carrier to try to get recovery. You're looking to one carrier to provide liability coverage, and then you're looking to them as well to provide underinsurance benefits. And in that limited circumstances, this owned and regular use exclusion has been enforced throughout the country.
I don't get that. There's other insurance policy, which is Conley's. If Conley could pay $1 million, we'd be done. Conley's the tortfeasor here, right?
She is, but because she's operating our vehicle, technically she would be, the argument is that and it's been determined and agreed by the parties that she's covered under the primary policy up to the $250,000 limits. Our primary policy.
And she's covered under her own policy, too.
Well, both, overlapping coverage. But what they don't get, and they can't argue that the chapter or section 113 somehow mandates that optional coverage, and I want to say that again, optional coverage, this is not compulsory coverage, this is optional underinsurance benefits in an excess policy are mandated by any statute. 113 doesn't say it, no cases say it, and that's what Justice Kerpelani
But what about the
noted.
argument that regardless of that, your UMI non-excess policy has to cover this, and it doesn't?
The primary?
Not the excess part, but the first part of the UMI has to cover this, and it doesn't.
That'd be, they haven't raised that argument. In fact, they concede throughout and don't even appeal the issue about whether they're entitled to UMI benefits under the primary policy. They agree they are not because of the limits issue, and also, I think, because of the owned and regular use exclusion, which, by the way, should apply both to the father and the daughter.
I thought you gave them the regular UMI amount.
We're giving them the $250,000 in liability coverage for Connolly's liability.
Isn't that the regular UMI amount under your policy?
It is the regular UMI amount. But
So I don't know why they would challenge that when they get that money either way.
well, they could get, what they're trying to do is get both. Arguably, they would try to get both, and that's
Right,
what-
they're saying your UMI policy, your normal UNI policy is illegal, and therefore its exclusions can't be applied even to the excess.
Yeah, but they're not arguing, they haven't made any position. You can read your brief. They're not even contesting the determination that they don't get UMI under the primary policy.
Well, why isn't your normal UMI policy illegal? Why isn't this exclusion, as applied to the normal one, illegal?
If you look at Chenard v. Commerce, I think it answers all of the questions that have been raised here. Chenard talks about how exceptions to coverage are perfectly legal and not violative of Chapter 113L. What they're trying to do here is suggest that 113L, Section 5, somehow, some way mandates underinsured benefits on an excess policy for optional coverage, and it doesn't say that. Chenard clearly says that you can have exceptions to coverage and that aren't written into Section 113, and it doesn't violate it. There, it was an owned but not insured exception to coverage. It also goes even further, and it says when you have a claim for uninsured benefits or underinsured motorist benefits, you have to look at the terms and conditions of the policy. The language is very clear in Chenard that we have to look at the terms of the policy to see whether they would qualify as an insured. And then it also goes even further by saying that you don't get uninsured motorist benefits under all policies, under all household members, for all circumstances. So I think Chenard really controls and answers that question. And the other thing, Justice Ditkoff, to keep in mind, they have not a single case, and this is what Justice Kirpalani said, not a single case in the Commonwealth, trial court otherwise, that has ever suggested or taken this position that owned and regular use exclusion is somehow violative of Section 113L. This would be the first one. There's no basis.
Well, it's never come up either way, right? It hasn't been decided either way, right?
That is true.
And a lot of other courts in other states have come out against the insurer in related contexts, right?
I don't think, I wouldn't use the words a lot, Justice Toone. I would say there's three that they can point to, and the majority rule, as was conceded moments ago, the majority rule clearly is that there's no problem.
No, that's the issue, the first issue. But the own regular use, there is more courts supporting the insured's position than the insurer's position. Isn't that correct?
I don't think so. I don't think so. I think we've got a string citation, Your Honor, of a half dozen cases, and they point to three, two of which emanate from Washington State, which has a very different insurance process. And again, I don't think there's anything anywhere that suggests that the commissioner somehow approved or accepted a policy that was violative of the statutes. That seems to be pure speculation on their part. And again, I guess I'll end where I started.
Well, before you do that,
Yeah.
unfortunately, I want to take you back to the follow form provision.
Yeah.
So
Yes.
It also says the provisions of this policy, which is the excess policy, supersede and replace similar provisions in the underlying policy. If the excess policy supersedes and replaces similar provisions in the auto policy, why don't the express policy's UIM coverage provisions supersede the auto policy's UIM coverage provisions?
Because I think you have to read further into context where it says, as you asked earlier, Your Honor, that it can be no broader than what's in the
Yeah, so on the one hand,
policy.
it says it supersedes everything in the underlying policy, and then the next sentence says, wow, it can't be. I mean, it's like it's incredibly difficult to scan that provision, and because this is kind of critical to people who buy these policies, shouldn't it be very clear as to how the follow form provision applies?
Again, Your Honor, I think it does say, it is clear that when they're talking about follow form, it says the provisions will supersede and replace similar provisions of the underlying policy. To the extent there's any type of contradiction, there's none. There's none at all.
There's no exclusion in the excess policy UIM policy. There's no the exclusion that you're relying on is the exclusion in the auto policy.
Correct.
And that exclusion doesn't exist
Understood.
in the UIM provision of the excess policy. So it seems to be like, well, that doesn't the excess policies provision supersede and replace the policies with the exception, with the exclusion in the auto policy?
But there's no similar provision, like there's no different owned and regular use exclusion. There's just nothing in the excess. The only thing we have in the excess policy is a express statement in that section of the policy, and this is in the actual underinsured section where it says we're going to follow form. That's what it says. So I don't know how someone could be confused and say, well, I don't know, it's in the underinsured section, and I don't know what that means that we're going to follow form with the primary policy. There could be no confusion. It's very clear that it's following the form under the underlying insurance.
All right. I'll have to leave it there.
Thank you.
I'd like to thank all the attorneys today. I'd like to thank our timekeeper and our court officer. I'd like to thank Judge Nyman for substituting in for the first case. With all that being said, court will stand adjourned until tomorrow at 9:30 a.m. in the Hale courtroom.